All right, good afternoon. Welcome to the Thurston County Board of County Commissioners Board Work Session, Tuesday, March 12, 2024. It is 1:03 p.m. My name is Ty Mentor, Chair of the Board. We have Commissioner Carolina Mejia and Commissioner Gary Edwards, as well as Commissioner Emily Klaus. We have Interim County Manager Robin Campbell, Assistant County Manager Rob Gelder, and we have our elected official check-ins, which are going to be structured a little differently now, with where we do a smaller number of offices at once, rather than a round table with everyone. And today we have Superior Court. My agenda says Sheriff's Office, although I was told we also have Prosecuting Attorney lined up.
I was told that it
agenda.
should have been the Superior Court, the prosecutor, and the sheriff. But I've heard that the sheriff will most likely not be able to attend.
Okay.
And I'm not the prosecutor, I'm not seeing.
You know, the prosecutor is
so
doing a murder trial, if I remember, but he may have a representative, so we'll just assume that prosecutor. So we've got 2 hours, and so that's at least 40 minutes for you guys, and maybe even a little more if you needed it, since we may not have the sheriff. So we have Presiding Judge Skinder and Kristen Jensen, our court administrator for Superior Court, to kind of give the board an update and Q&A, whatever you got. I'll turn the floor over to Judge Skinder. And
I appreciate that.
Yeah.
Thank you. Well, I thank you for having us, and I've been able to talk with a few of the county commissioners. I haven't had a chance to talk recently with Commissioner Edwards, but I know we have a meeting on the books. The biggest thing I guess I wanted to use the opportunity was, and I've talked about this individually with a few of you, so I hope you'll give me a little patience and grace on this, but we are in the process of trying to make our criminal case flow work more efficiently. So we've had probably about 9 months of meetings with the prosecutor's office and with the Office of Public Defense about ways to make fewer court hearings and having cases try to be a more efficient case scheduling. So the idea is, and many of you that are familiar with our system, the omnibus calendar. The omnibus calendar is really a pretrial, and pretrial, those are very large volume calendars. And they're, especially during COVID, there was a tendency to have those hearings get continued 1 or 2 weeks. These were practices that we had largely put a stop to when we had the Center for State Courts do a study about probably 2016, 2017, that looked at ways to try to make our court system work better, to have every hearing be meaningful, and to be able to try to reduce the number of hearings that we had. During COVID, when we lost the ability to have cases go to trial with a jury, that took away some of that forward momentum. And so we've been working the last 9 months on ideas of how to make that first omnibus more meaningful, with a real focus on trying to get an omnibus order entered at that time. So that way, if there were additional motions hearings that had to happen later on in the case, there would be plenty of calendar space, and we weren't taking up a lot of time for what in many cases is a very procedural type of a court hearing. That's what the omnibus had become. So we had representatives from public defense, representatives from the prosecutor's office, Judge Wilson, myself, our operations manager, Ms. Moore, our criminal case coordinator, Ms. Morales, and we all worked on things that we could do to make the system work better and to get back to some of the changes we had made back in 2017 after the Center for State Courts came in. That produced a new omnibus order that we're using now. We just were able to put that into effect. We had a extended judges business meeting not this most recent, 2 weeks ago, Sunday and Monday, and we got that ratified. And then a lot of the other ideas that subcommittee had been working on, the judges approved. And so that's significant. We had our over 365-day list come out today, and when I first looked at it, I was worried because I saw it had gone up to 24 from 22. I didn't like that. So I started digging back through it. That's what I was working on when you all came in. There are 5 cases that shouldn't be on that list any longer, One of them is the case that you referenced, Commissioner Menzer. It's the case that they're currently, one of those cases they're currently in trial on. There's another case that's currently in trial. And then four other individuals have pled guilty. And so they should not be on that list any longer. They're pending sentencing, and so they're in a different position. So that list looks like it should be 19 or perhaps even 18. So that's what we want to see. We want to have that list of people that are held in the jail for a long period of time pre any disposition. We want to see that list get reduced. Again, just to help perhaps, the reason sometimes that happens is it happens on cases that are complex, generally speaking, very serious charges. Also cases where people have significant mental health issues. The significant mental health issues, I know you all are doing a lot of work around with the state as well about how Western State Hospital is dealing with the large number of individuals that have co-occurring or significant mental health issues that call into question their competency. Under state law, if competency is in question, the case basically goes on a pause, meaning we can't have a case go to trial. There can't be any active movement on the case until that question of competency gets determined. And so those cases, because if the initial evaluation, which the attorneys agree with, calls into question that that individual that's charged with a crime cannot assist their attorney and does not have the capability of understanding the legal proceedings, then there will be a period of competency restoration. Periods of competency restoration are done at Western State Hospital. There can be multiple periods of restoration depending upon the severity of the crime, is the way to look at that. So those things also cause the lifespan of a case to enlarge. So I'm sorry, I feel like I'm talking a lot. I want to be able to really, more than anything, be able to answer questions you all have, because I know you get questions often about why things take so long, for example, or other things. And so I'm happy to answer those questions. But I want to give a rundown about some of that work that we're doing on the criminal side to make things work better. This is an area that's near and dear to me because I had a long time in the prosecutor's office in Thurston County. Before that, when I was a brand new lawyer, I worked in Lewis County Prosecutor's Office. So I've been able to, I was reflecting when I was talking to court the other day, I've got, I think it's going on 28 years of experience in the system. And there are things that we know can make the system work better, make hearings more meaningful, and decrease the lifespan of a case, which are all good things. So if there are questions anybody has about those things, I'm happy to talk about them. Yeah.
Judge Skinder, I'm wondering how we compare with the 365 cases. How do we compare with the rest of the state? Are we right kind of on the average? Are we higher? Where are we?
It's a really good question. I don't have a good answer for you. We can look into trying to see what we can get from the administrative office of the courts. They're probably, as you know, the best ones that really look at that data that way. Not every county keeps these types of figures. And so Kristen and I, and Kristen's been great about reaching out to AOC and trying to find more ways that the administrative office of the courts can assist our county, because we really want to use that resource, especially because they're here. And so data is one of those things. The other is, it makes me think about justice counts. I just had, Kristen and I had our meeting with their representatives, and that was really interesting because, again, trying to look at individual pieces of data, understanding it's a snapshot, because one of the discussions we got into with that group was, could we drill down and look at, for example, like a specific case, and then look at, the different routes a case could take and look at timelines. And they indicated they couldn't do that, but they would really be willing to work with us on being able to do a snapshot of what our current population looks like. And so part of the issue with that, though, as well, was we don't keep our own data. We don't have staffing to do that. And so we really rely upon other stakeholders. And so obviously the clerk's office, huge because of Odyssey. And I think Odyssey we can do a lot with. But then the administrative office of the courts, because they also have that tie into Odyssey, that's the other partner. And so when we met with Justice Counts, we talked about how they really need to work with those people, and I gave them some names about ways that they could try to make sure that they were getting all that, all those connections as well. So to answer your question, I don't have a good answer off the top of my head. My sense is it's probably very variable. I think the same issues that we're dealing with mental health are across the state. I know that. And then I think the same pattern happens when a lot of times your most serious cases are the ones that take the longest to get to trial, because usually the stakes are so significant for both sides that, and a lot of times there's additional discovery requests. I know one of the things that we're dealing with in our county that other counties I also know are dealing with is the increase of video footage now as more and more law enforcement are using body cam footage and vehicle cam footage that, you know, you think about it, if on every criminal case there's 20 hours of video, someone has to watch that from each side, and they have to figure out what to do with that, and they have to have a way to be able to process all that. So I have a feeling all those things are extending the life of cases, especially on the most significant, because, you know, on a, let's say I'll just call it relatively simple instead of trying to give an example. A relatively simple case might only involve 1 or 2 law enforcement. But if you have a complex case, it might involve, you know, a dozen officers that have some role in the system. They all have their own footage, they all have their own reports, and so the issues get compounded. But if that's an area that you are curious about, I can certainly talk to AOC.
Just curious, just
Yeah.
wondering.
It's a good question. I don't know the answer. I've been so focused on ours, trying to get those numbers down.
At that point, I
Yeah.
mean, yeah, I can attest to the, you know, like in Alaska, when I was public defender, we had audio, and it was way before Washington did anything with body cams. Alaska State Troopers always carried audio, digital audio recorders, and every contact, they would just pull up to his house, turn on the recorder. So I had hours and hours, even, you know, you might think of, and in Washington, DUIs were the thing because the officers often had dash cams, and the whole investigation took place right in front of the car, right? So that would be the kind of case in Washington where, as a lawyer doing misdemeanors, you know, they might go, oh, this is a simple misdemeanor. It's going to take you 5 hours to do this case. I have 5 hours of video footage just to watch, much less writing a legal brief or interviewing witnesses. Or, I mean, it's, you know, so I mean, you can take a simple case and make it really time consuming when you add evidence. And it's good, it's all accountability, and it helps defense. And I mean, and I can tell you stories about how you might think, well, why, if I watched Officer A's video, why do I need to watch Officer B's? Well, guess what? A little side conversations happening. I've caught things that were said that were legally dispositive in my case because I watched a duplicative, you know, or in that case it was an audio, and I heard things that I couldn't hear on the first recording. So I mean, you as a defense lawyer, your ethical obligation is to review every piece of evidence thoroughly to try to see what is relevant to your client's defense. And you can't, I don't even feel like you can, I mean, ethically, you probably can, but I didn't even feel comfortable delegating that to a paralegal or I mean, I felt like I felt like I as a lawyer had to eyeball every piece of evidence in the case. And when that's a video recording, that's time.
You're right, and I think the same thing falls on the state, because a lot of times, you know, even in that case, let's say it's a relatively simple case, and there's, let's say, 2 law enforcement, and they've both done their investigation, and they have certain aspects of it that they have on body cam or video cam. There might be different things that at the time didn't seem particularly significant in terms of differences that came out of the investigation. But then when both sides are looking and listening, all of a sudden something comes out that actually is significant. And so I think we're gonna see, the concern I think we have is that I agree with you, having all that additional data and information is really helpful, but it requires that someone really be actively looking at it and listening to it. And that builds in work on the attorneys, and anything that impacts the attorneys that slows things down in their presentation then causes the case to also slow down. So, you know, I think part of everything that we try to do systematically is also give off-ramps, you know, in terms of, you know, not every case goes to trial. We know the vast majority of cases resolve short of trial, and there's lots of different ways a case can resolve. I just had drug court this morning, and you know, there's all these options that we have within the county, and the legislature is creating more. Most of those options are post conviction, so they're looking more at sentencing. But everything we can do to give people options and choices when appropriate to resolve their case in a way that gets them into what they need to make sure they don't come back into the system, that can be a good thing too. But there's a lot, you know, there's a lot of trying to balance the needs and interests of everyone and try to do it in a fair way that is challenging. And, you know, I guess what I would tell you is that Kristen's done this great job with really having we have a lean group of dedicated court professionals that are always trying to make our system work better. And people are dedicated to what the court promises that they'll do, which is give people a safe place to come and resolve conflicts in a way that they're treated with respect. And that's the part of my job that it's so significant. And I love my job. I feel very honored to be in this position. And so things that, you know, and I know every single commissioner and everyone connected with the commissioner's office, I know there are things that come up. And again, I just want to make you my promise that if there are things you're interested in or things you want to talk about, just let me and Kristen know, and we are happy to engage and answer those questions and have those discussions.
It was great to have you visit this week. That was really wonderful.
Yeah, I really appreciate it. It was kind of funny because I got a call the other day from somebody that's a newly elected council member in one of the cities here, and he was like, "Do you ever get imposter syndrome? You know, where you're like, is this really happening?" And I was like, "Well, yeah, it happened the other day. I went to the Supreme Court, and I'm sitting there with or Superior Court. I'm sitting there with the full bench of judges, and I'm in my mind, I'm like, why are they talking to me?" You know, and they were very kind, they were very informative, very helpful. So I really appreciate the time that you all carved out for that.
Definitely. Well, I mean, that's, you know, we were able to have Commissioner Klaus, you came over too, and we have the larger group coming for you. And it's important to Kristen and I to have relationships with each and every one of you. And so we love these opportunities. We can't always come in person, and I know you all are busy too, but we want to try to make that commitment because we think the relationships are important. And it's one of the things I brag about Thurston County all the time when I'm talking with people out of the county is that I think we are fortunate, and I think we're fortunate for a bunch of different reasons. One is we have really awesome people in this county. I mean, I'm just going to say it, we do. But we also are small enough and nimble enough, but big enough that we have the ability to try things. And that's what I think is exciting, that, you know, a lot of times we're able to be creative. I think Thurston County has always been on the forefront in the state of Washington on a lot of issues about how to make system of justice work better. And that's a credit to everyone here. And so we are committed to making those relationships and keeping those relationships and working on them. So we appreciate the invitation.
I got a question on your case flow thing.
Yeah,
So
you bet.
back when we were working on it the first time around before COVID, and I can't remember if you were on the bench then.
I wasn't.
Yeah, so you're the best person to ask, actually, because you'll understand exactly what I'm talking about. One of the things we encountered about making the, you know, omnibuses meaningful and all that was that the prosecutor's office had pre-printed on their offer sheet, this offer expires at omnibus. Well, that, you know, you have every right to say that, but that creates an issue for the systemic idea of trying to not have meaningless hearings, because as a defense lawyer trying to make a plea agreement for your client, you know, you often were working out little details of that agreement, and that required to bump that hearing, because once that omnibus passed by, and some prosecutors were harder about it than others, but some of them were rigid, like, nope, omnibus, I learned the hard way my first year in Thurston County when I had a colleague cover for me at Omnibus, and we had a witness interview set up for like 3 days after, and I was gonna accept the offer once I had that interview.
Right.
And my colleague went to Omnibus, and I did the interview, and I called the prosecutor, and I'm like, okay, we're good to go. And he's like, nope, that expired. You entered an Omnibus order. That offer's off the table. We were talking about 14 to 17 years in prison. So like, my heart dropped out of my, to the bottom of my, but anyway, we tussled with that, and I know that, that discussion and how the prosecutors and defense lawyers can get past that is gonna be critical to getting past the not having the hearing be the thing that, because that, you can't just call up Judge Skinder and get the omnibus bumped a month because you need a little extra time. You're on the docket, you have to show up.
So there's been.
So how do you deal with that?
Yep, no, it's super fair. I hope I wasn't that deputy prosecutor.
You were not.
So what I would tell you is this, the prosecutor's office is part of those, over 9 months of meetings, was they've agreed not to have the entry of the omnibus order be what would cause them to end plea negotiations. Now, there could be other reasons,
Sure.
right? And so, does everyone know when we talk about an omnibus order, what we're talking about? You do, yes? Do you?
I know what the word means.
Okay, so, no, the reason I'm asking because, so it's a 4-page order that gets done in every case if the case doesn't resolve first. So if a case looks like it's going to trial, and the way I think about it, the way I explain it to people, is it's a roadmap or a recipe of everything that has to happen for that case to be ready to go to trial. So basically going through all the different types of legal motions, discovery obligations, potential defenses that are being argued, any stipulations, witness issues, basically everything that has to happen. So that trial date, which should be a realistic trial date, can actually occur. And so when it gets entered, both sides are saying, these are the things we think need to be done. And then the court's going through, asking any questions, and then that's the order on the case that sort of governs things. Now, there are always ways to potentially revisit an issue if something comes out. Let's say there's like new discovery that happens after that point. There have to be ways to deal with that, and there are. But it's a pretty important document. And so what used to happen was there was what Commissioner Menzer is saying exactly right. It used to be, if defense wants to enter an omnibus order, that means from the state's perspective, the case is going to trial, we're focused on litigation, and all efforts to resolve the case end. And so there's been the commitment that that is no longer the case. They don't tie it to that. There could be case-specific reasons that they'd have an expiration date,
Yes.
and that's between the attorneys to negotiate, but it's no longer the omnibus. And actually, it's interesting you brought it up, because probably about 6 months ago, when we were doing these meetings, there was a little flurry of this that was coming up before the court, like, Your Honor, we don't want to enter because this, so we worked through those issues.
Yeah.
We kind of collaboratively, system-wide, and that's where we're at. So that does not happen anymore.
Because from the prosecutor's standpoint, just to take their side for a minute, when the omnibus order goes in, then that's when the reason they would say that is like, well, then we start doing our trial prep. I give the paralegals, we start subpoenaing witnesses and getting prep ready. So once we make those investments, we want to negotiate, if we're going to negotiate, and then once we set that aside. But there has to be more flexibility, because what would happen in this situation is, here the court, and I'm pointing to the court wants to minimize hearings. But if I'm the defense lawyer and I've almost got a deal, but it's omnibus hearing and we don't quite have it, like, I can't enter an omnibus order if the prosecutor is going to draw that red line. And so I have to continue on, instead of just entering the order and saying we're still going to be able to enter a change of plea next week. If they're going to say, nope, if that's a hard line in the sand, then we have to continue the hearing and we've just doubled the number of omnibus hearings for literally no reason.
Correct.
So there just had to be a give on that in order to make this all work.
Yes, like back historically, and Commissioner Mejia she remembers, like, you look at a case and you look at the procedural history of a case, and there might have been a dozen omnibus hearings. And you think about that in the amount of work that has for everyone and the amount of court time, that if we dedicate court time to that, it takes away court time for other things. And what we want to do is be able to have more time for the motions and the other work that needs to be done, so those things can happen, and then we can keep those trial dates. And if we keep those trial dates, that allows the system to work more efficiently. The other thing that we're doing to sort of, just so you all are aware, is our family and juvenile court. We have our 2 assigned judges to family and juvenile court, and then we have 3 court commissioners there. They struggled similar to us, some different issues, but COVID had an impact there as well. And they ended up with a situation with trials. They had more trial work than they could handle in that building. In fact, I think you all know that they really need to have more room. I mean, that's one of the things we're struggling with as well now, because we've created some criminal calendars on Friday at the main campus that we're using Chandler every week. So we're trying to make the most use of all the space that we've been given. But family and juvenile court, we're trying to do more things to allow judges at our main campus, because we have 7 judges at the main campus. 2 of them are assigned for the criminal rotations, and 5 are trial judges. So if there are trials from family and juvenile court that we can get to with looking at the criminal trials, looking at the civil trials, and then trying to be able to also prioritize some of the high priority dependency and termination work that happens at family and juvenile court that they don't have the judicial capacity to get to, we're also trying to build those in. So if you look at our weekly trial schedules, we are getting a lot of trials out. And again, sort of that idea that it doesn't seem like it, but the reality is once attorneys know their case is confirmed for trial and they have a date that's going to start, and on the criminal, we do that confirmation hearing 11 days before the start of the trial. Once they know that, it allows the parties a lot of time to figure out whether it's really going to go or not. A lot of times, just them knowing and them getting geared up for that final push that they know they're going to be in trial for the next 2 weeks, if they can't resolve it, allows, when Commissioner Benson talks about flexibility, a lot of times at that point, cases will resolve. And that happens in every type of court case. When attorneys know, shoot, we've tried to do our best to resolve the case, the other side's done their best to try to resolve the case, we can't resolve it, we're going to trial. The reality of that trial staring them in the face, and they know they're going to be before me on Monday, a lot of times leads to the little extra push they need, that they are able to come up with something that both sides can live with. And so again, it's the sign of a healthy court system. If we can get a lot of cases scheduled to go out, we know the trials that do go out, wonderful. We've got 3 criminal trials going right now and 2 family and juvenile court trials going right now. So that's a good sign. And that's what we're really trying to do, is maximize, because we know that makes every other part of the system work well. When I have on a lot of times, I'm trying to think, yesterday or today, because I was able to move we had a judge out ill today, and so we had to shuffle things around so I could come, but our change of plea calendars become full to the max. Well, that's a good thing, because that means, again, the system's working well, and we need to have enough hearing space for all those things so we can accommodate that. It's part of the reason we created that Friday calendar that I'm talking about. We tried to build in almost a safety valve. Those calendars are set by court order only. And so the ideal situation for those, not limited to this, but a case confirmed for trial, the parties know they're going to start this coming Monday, and they reach a resolution. Well, a place to put it, because right now our calendars are pretty full, so we have that Friday that we can set by court order. So, and this actually happened with one of the cases on the 365 list for this week. It was a attempted murder case, and it was set for trial to start this Monday. And the attorneys came and asked for a hearing on Friday, which I handled this past Friday, and the individual chose to plead guilty. But it was to give that safety valve. And also, if there was, let's say, a late motion that came up that wasn't captured in the omnibus, so it could have been set ahead of time, but the parties need the evidentiary hearing before the trial starts. So there's something that one side or the other is trying to suppress or prevent the other side from using. We didn't want to have a continuance automatically have to happen because that issue had to be resolved before trial. So now we can stick it into a Friday right before the trial if we need to. It's other sort of last minute things or cases where the attorneys might be in trial on a particular case. When you talk about the prosecutor in trial, he's in trial Monday to Thursday. Well, where can he put a hearing that he needs to have on the criminal side, where he could put on Friday, because that's usually a day we don't have jury trials because our trial judges are doing their civil calendars on Friday. A lot of information. Sorry. Yeah.
Can I ask on the civil side?
Yeah.
How that's coming along? The civil also had a backlog, just, COVID, right?
Yep.
So I'm wondering how that's coming along specifically with trials. Are we starting to catch up? And then I guess also on another note, like with state cases, are we starting to see more cases come through from the state, or kind of been pretty stagnant so far?
I'm going to defer the second half of your question to Kristen, because I know she's been monitoring that. She has a good sense of it. On the first part, we've really been trying to prioritize civil trials. So what I do is each of the trial judges, basically the way this works, just for everyone to have an understanding, is if you broke out the whole year, and I could, if you all are interested, I could always bring how we have our schedules. But the judges have a certain number of weeks every year that are dedicated where their civil trials are their priority. And then we have criminal cases, and then we have what we call an unassigned bench trial. And so we have specific weeks broken down into groups of weeks for every trial judge for all throughout the year. And for the civil trials, what Judge Wilson did and what I'm doing is I get information from the civil judges about what cases they have that are coming up for trial. And you're right, the backlog hit civil maybe in some ways worse than the criminal, because on some of the big cases where civil trials can be even more difficult to schedule, a lot of times because of the heavy use of experts or just the way the witnesses get scheduled, I think, is it becomes more costly and problematic for a lot of civil cases for the attorneys to get those people on tap if they know there isn't a very high chance they're going to go. And so there's always this, I think, challenge for the civil practitioners about they want their case to go, but they can't afford to have it go through multiple trial sets. So what I've asked all the trial judges to do, and they've been great about this in just a few months I've been doing a couple months now, going on 3 for the trial schedule, is getting me information of the cases that they have on for any particular trial week. They have a lot of civil cases that'll be on for a particular trial week. We're looking at age of that case. We're looking at whether it's been bumped before. We're looking at other issues, like we had one recent with there was an important witness in the case that was quite elderly, and there was a concern about what effect a continuance would have on her availability to be able to be there for the trial. So like all these types of issues. And so for me, as I'm trying to devise that trial schedule with our operations manager, it's trying to give high priority to the cases that need to go out. And so we've been successful, again, sort of big game of Tetris of trying to fit as many cases that we can that are the highest in each of these areas, which again, the benefit to doing this in the scheduling usually more than just a single case, because if a single case is, God, you're okay, it happens. If there was only one case before a trial judge in a particular week and that case resolved, we want to be able to have them switch gears and go into another trial. So usually in those civil trial weeks, we'll have multiples, so that way if something does go off at the last minute, we can have another one go in. So I think we've seen good success with getting them, but there still is catching up.
As to the state cases, you know, it's ballot title season, so we are seeing those. Some come with multiple parties or multiple challengers, so we're monitoring that and need to check with the clerk and to see what the numbers look like compared to previous years. I don't have a sense that it's worse this year.
Not yet.
I think we're still early on. And then we can see some additional challenges now that we've had signing day and the legislative session's over. Sometimes that means that new laws that are enacted can be challenged, so we're watching for that.
So I'm not sure, does Commissioner Cos and Commissioner Fournier know that we do all the state cases or Superior Court talk?
Judge Skinder and I talked a little bit about that the other day, and then, you were in the news recently over a big one that was, fairly, well-known throughout the state.
The thing, because we're the state capital, we get a lot of really interesting issues in our county. And
The Big Bertha one was.
it's hard to define what's the big one, right? They're all, but I mean,
Building Code Council is pretty huge.
what was that?
Judge Murphy just decided a Building Code Council
Yeah.
thing, and I'm on that council.
Okay,
so-
yeah, I mean, the work touches everybody. Of all the cases that come before us, it's, again, that's why I say, I step back and every day, I appreciate what you're saying. It's like sometimes you're just fortunate to be where we're at. And what I would tell you is every one of our judges, and I say this, everyone has a different, there are different things that are maybe what drives each individual judge, but we've got a group of really dedicated, hardworking, caring, knowledgeable judges in this county, and I think that it speaks really well of the county.
If I could add to that, we also have very dedicated and hardworking staff, and it's a challenge oftentimes. Right now, we're in a period of another challenge. We had some staff depart at the end of the year, which meant we recruited. We had some great staff that promoted into those vacancies, which means we then have to recruit for their vacancy. And we're also going through some other challenges with one of our key staff members who plays that game of Tetris so effectively, departing for an opportunity in another county. And so that'll be a huge recruitment. Our operations managers are really key to keeping the daily operations going and functioning well, and that's one of the positions that'll be vacant very soon. So staff are rallying. We also have other staff members out that are in key roles that are out for extended medical, and so that puts additional strain. Our staff has been through a lot this year. We've had a number of either our own staff or family members of staff that are dealing with serious medical conditions, cancers and things like that, and so they've all stepped up. And of course, I'm trying to be supportive so they don't burn out, but we have a lot of challenges, and so I just want to say also we're very proud of the staff that we have and that they do continuously rally. I feel like I go to them over and over every few months and say it's time to rally again, and they step up, and so I just really wanted to give them kudos for that.
The biggest question or complaint or concern that I get from citizens is regarding, pretrial release conditions, and that's, it's a big topic these days, and
Huge topic.
yeah, and that's really where most of the questions come up, and,
Well, I tell you, I encourage. Those of you who heard me say this, I'm not trying to be super repetitive, but I'll say, all of those hearings are broadcast. We're on Zoom every day, and I know when I do the preliminary appearance calendar, I take a lot of effort to explain. You have to be cognizant of time because we want to get all those calendars done, of course. But I try to explain exactly why I'm doing what I'm doing in a particular case. And those are hearings, I think a lot of times people don't know that they can tune in and listen. They can just come on an observer. And I've encouraged, everyone, like if you want to listen in, all you got to do is log on, put yourself in as an observer, have your camera off. You don't need to identify yourself. I mean, if you want to, you can, but you don't need to, and you can just listen. And, you know, I know it's an area that my sense is people are frustrated by things they see and people want to have something happen. But again, you know, our system is one that, in my view, even though there are faults in our system, and we know that, and I think everyone here in some way has worked on ways to try to improve our system, the reality is I think it's the best system in the world. We have a presumption of innocence that if the government makes an allegation, someone has certain rights that are, they belong to each and every one of us to have that presumption of innocence, to be able to be a presumption that under our state constitution that someone's going to be released. And so, you know, a lot of times when I engage in people on these issues, one of the things that, you know, I hear is people say, well, someone deserves consequences. And I'm like, okay, but consequences come with after someone either pleads guilty or a jury. Yeah, it process. So, you know, one of these things, I had a conversation with the sheriff a while ago, and it was, we were talking about some of the things I was talking with you about, how we were trying to, and we saw the benefit of now, this was a little while back, as we were recovering more and more from COVID, and we were able to, you know, be having jury trials go. And one of the concerns that the sheriff, I thought, had, you know, put his finger on was pre-trial decisions might have taken on additional emphasis, especially when someone couldn't go to trial, because that lifespan that we're talking about of a case was longer.
Yeah.
And so if there is that pre-trial decision and then a trial happened, and we're not to this point, even though we do have some cases go to trial on a 60 or 90-day initial trial set, that's still not the norm. The norm is usually there's a continuance that happens. But let's say we ever got to a system where every case would go to trial within its first 60 days, that's if someone's held, or 90 days, and that's if someone's out of custody. If that happened, the focus would be, okay, well, this is a pre-trial status. This person's not been found guilty of anything yet. And so, or at all, right? I mean, where you're at in the system. But if the time it took for a case from when it was charged to when it got to resolution was 2 years, well, now the significance of that pre-trial determination takes on additional weight. Does that make sense? Mm-hmm. Okay. And when we were talking about that, I was like, well, I get that. And I get that people are frustrated. But again, it's like, for me, I think when you give people real world examples of, and I, you know, we all have seen these. I know Commissioner McKee has seen them where, you know, a case would come in on the preliminary appearance calendar, and Commissioner Mentor's seen these too. And it looked really not good. Like, you read what was alleged and it was not good. Commissioner Edwards also a lot of experience with this, you know, and then the court finds probable cause, sets whatever the conditions are, and then that starts the clock for the prosecution about whether they file charges or not. Lots of times the state, after having that period of time and additional law enforcement investigation, they go, we're not even going to file charges. And so, you know, or a situation where they do file charges and then a month in, after they've done additional investigation, defense has worked the case, both sides have talked, it's like, no, this case needs to be dismissed. And I sign dismissals, you know, every day that get presented.
But something's going on, right? If crime rates are truly going up, I wouldn't say it's like there's more people committing crimes. It's usually, I mean, it's a small percentage of people that are out there committing crimes. So is it, you know, there's more people out there? Is it like human behavior is changing across the board, or the same segment of the population is engaging in that human behavior? It's just they're out there and they're more available to do it because, you know,
well, I know
they're not held on this, they're not held on that.
I think we talked about the 20-80, you know, I mean, the idea that 20% of people commit 80%. Yeah, I mean, so I think you're right to say there's probably a group that are the people that are using a large percentage of court services and law enforcement and medical and ER and first responder services. And I mean, that's why we do things like, for example, a drug court, which is aimed at that high risk, high need people. But in terms of like other things that are going on, they're interesting. I mean, and I'm always happy to have those conversations, but if we look at our system presumes that people aren't going to be held unless the court makes a separate finding. And those separate findings are substantial risk that someone's going to commit a violent crime.
Yeah.
Substantial risk they're not going to come back to
But have
court.
we changed how we make that determination? Is it like, this community risk assessment, or is it just philosophical leanings of judges, or is it?
I think what happened, and I think, the areas around criminal justice is, I think of, and Commissioner Edwards probably has a good perspective of this, it's a pendulum, it swings. And I think you see different priorities over time. There was, when I was within my first 5 years of being a deputy prosecutor, I handled a lot of the drug task force cases in Lewis County at that time, which was when, this was mid to late 90s, when methamphetamine was rampant in Lewis County, and you had meth labs everywhere, and you had a lot of problems. The legislature had said it was not unusual for a sentence for manufacturer, someone was getting 20 plus years in prison. That was not unusual. That is so different than the system that we have now. So I mean, I think you see changes that happen, and I think pretrial, it's one of those areas that there's been a lot of study, because what you see is a couple things, and these conversations are great conversations to have, like one-on-one. They're tougher in a group, but I'll share a little. It's the idea of, is money bail going to do what we all think it might do? And I guess the way to think about this is, let's say you have someone that is very well off financially that commits a crime, and then someone that's not very well off financially that commits a crime, right? And the court sets conditions of release. And again, those conditions of release should be non-monetary. They should be on expectations of the court. And those are, have no criminal law violations, don't have any contact with this individual, report to pretrial, do X, Y, and Z, don't do these things, don't drive a motor vehicle, all this. If the state learns of what they believe to be a willful violation of one of those conditions, they have the ability to bring back before the court a motion to modify or motion to revoke the conditions of release. The court takes that information in, gives defense an opportunity to argue, and the court makes a determination. But if we look at that initial determination, is the setting of a monetary bail, is that going to make it more likely that those conditions of release are followed? Because the idea of the monetary bail is a monetary bail that the person can put up, get released, and whether that amount of money is going to make it more likely that they're going to follow those non-monetary conditions. And what you see sometimes, and I think you'd see historically, is sometimes conditions of release, if the court didn't make one of those findings I'm talking about, the court could set conditions high. Well, the point of that can't be to keep the person held pretrial. The point of it is to make sure they follow the conditions of release. And so you get into this very challenging situation, because you're not supposed to set a monetary bail. The idea of monetary bail was like the idea of having skin in the game. If you have X amount of money, that means it's more likely that you're going to follow the non-monetary conditions. Well, research has not shown that to be accurate. So, there's a lot of people across the country that started looking at this issue years ago. And they're like, well, it does not accomplish that. So then you get into this situation where you're using, if you were just to use a monetary bail, you have the impact of keeping certain people in custody and other people out of custody. Intellectually speaking, if someone can't post a monetary bail only because of their financial circumstances, that's a reason they can come back before the court and ask the court to modify the monetary condition, because that shouldn't be what's holding them. Again, it's hard to, in sort of in generalities, because there's those other conditions I'm talking about too. If there is the substantial risk of a violent crime, if there is the risk someone's not gonna come back to court, if there's the risk that there's somehow maybe if there's a no contact order, they're gonna violate that no contact order or tamper with the witness. Those are things that can take you outside of that, but you're still, those overall framework and guidelines are still the ones that are supposed to be followed. And so I think there's an expectation a lot of times from people that care about these issues in our community that they want to see someone held accountable. But they can't be held accountable to a point they haven't even been charged with a crime, and certainly haven't been found guilty of a crime. That's the tension.
Oh, yeah. And if you err on the side of holding people in, that means that in many cases you're holding people's liberty, like you're balancing
personal
liberty.
liberty versus
Yeah.
community safety.
So people,
That's
like,
the argument.
if there's one, I would be nervous about a system where there was because the judges don't have perfect information. They can't predict how people are gonna react. So if they're setting bail in such a way that there's no violation ever, they're probably being over aggressive, which means there's a substantial infringement of people's personal liberty. People are being held in jail for no good reason. And nobody seems to wait. You can always point to one case, but the alternative is a whole bunch of other people being locked up for nothing, in a sense. I mean, that's the.
Well,
Then you
practical
see
reality.
crime rates, and you're like,
But
what's
it's-
causing this? What are we doing
and
different? I don't know.
Because I saw this about a month ago and I was like, this is gonna come up in a board conversation. I don't wanna- And this is not local, obviously, but it just flies in. I mean, this is from a business, Reuters, Business Insider, whatever. US homicide rates dropped by 13% in 2023, according to preliminary data from law enforcement agencies. The record-breaking decline comes despite concerns about perceived growing crime rates. The historic figures mark the largest one-year drop on record. So
We just had 3 this last weekend.
yeah, I understand, but,
Probably not dropping.
I just
rates
keep
here.
getting conflicting information about what's really going on, and, the data never seems to back up the community perception, which leads me to believe that, someone's got a motive to stir up perception that's not being backed up by data.
There was a pretty high-profile case, a sports figure here up in King County that was recently held for a drunk driving thing until he got picked up on a Friday, and he was in jail till Monday or something like that. Makes you kind of wonder, because he obviously could have afforded it,
Because he ended up only, I think the charge was just a DUI.
I don't
correct?
even know I don't even know what it was exactly, but it was just, when you talk about monetary bail, obviously, he had the ability, but for some reason, somebody,
So it was on a Friday night.
yeah, it was on a
And
Friday
the judge
night.
coming in till
And
Monday.
he didn't get out until Monday,
Right.
so.
Well, it's like everything, for us, we have the Constitution, the law, the court rules to apply. But I think if you step just out of that for a second and look at it societally, the way I think you have the ability to look at it as county commissioners, is there's a sweet spot. Because I think what Commissioner Menser is saying, what I hear is well, we could have a system where every time someone was alleged to have committed a crime, we hold that person. Now, I'd argue that's not the way this country and the way our court system was designed. But I mean, that is the system. You say, if you've been accused by anyone of committing a crime, you're held until your case is resolved. Our jail populations would look very different than that.
And then, but as a judge, you could sit there and go, this is the only way I can assure that no one's that I
But there's
release
no
goes out
risk.
and commits some horrible crime,
Sure.
and it looks like I made a mistake.
Sure.
If that's, you're gonna err on that side, think of the amount of people being held on nothing.
Yeah,
Well,
and
and-
we're good at creating processes and systems, and we have things like that community risk assessment that gives an advisement to a judge, and
Well,
are
can I-
they
can I-
real? Are they effective?
Can I address, I mean,
Please.
it isn't so much that it gives it's giving advice. What that project was really aimed at doing was looking at these 9 distinct factors that when we look at them is a broad class, not necessarily that specific person, but when we look at someone like this person. So someone that, let's say, doesn't come to court, has had violent offenses, had their first crime before they were 21. There are these factors, right? And so what that's doing is it's saying, court, if you put this person on pretrial supervision, we're gonna have this person on one of 4 different levels of supervision. 4 being the one that's the most intensive from our pretrial, the most support, the most checking in, the most contact. A 1 being the least amount. And they're looking at 2 scales as they try to come up with that. One is the risk the person's not gonna come back to court, and the risk that there's gonna be a new criminal law offense. And so it's really statistically driven information about what the population looks like that hits a yes or a no on those 9 questions, kind of what that equates out percentage-wise. And what's interesting is even the people that score as the highest risk to not come back to court, the percentage of the people even in that population group, the percentage is, say, that the vast majority of those people are still gonna come back to court, and the vast majority of those people are not gonna commit a crime. So again, I think your point that we're dealing with this smaller group is, I think it's a fair point. But all these factors that get looked at, I think we all can think of a situation where, let's say, it's tough because I want to be conscious of time. Someone can be accused of something, right? And we all might have a different opinion of what is going to help that person ultimately be successful. And by successful here, I mean not commit another crime and come to court. But from the court standpoint, we're trying to set those conditions very clearly. And then if those conditions get violated, that's when, and we just had a mapping meeting with all local law enforcement, prosecutor's office, public defense, our pretrial services, then the prosecutor is the one that would bring a motion to modify the conditions of release or ask the court to revoke the conditions of release. And there's different standards that apply to each of those different situations. But that's sort of that procedure. So we set those conditions, and if someone doesn't follow them and the court gets that information, then the court can address that conduct. I mean, and so I want to be responsive to what you're saying.
Yeah.
Does it hit what your concern was?
A little bit. I
We
mean,
have another meeting that we're gonna set,
oh, yeah,
right?
yeah, I mean, there's a lot to talk about,
There
you
is.
know? And there's a lot of things that affect why a person ever comes before you. And there's a lot of things to discuss about, like how you as a judge fix the problem, Not just for that person, but for the victims and for the community and.
Well, I guess what I'd say on that is judges, we deal with issues that are brought to the court. So, we are in a different role. It's not so much, like a lot of us, and myself included, we work on issues outside of the courtroom that we're in to try to better the system. But regarding an individual case that comes before us, what our role is to be fair to both sides, to fairly apply the law, the rules, to listen to everyone, and to make the best decision we can based on the information given to us. So within the confines of the case, it's not like we're going in with an agenda. Like our agenda is we're taking in all this information, and then we're trying to make the best decision we can with the conflict that's brought to us. So, outside of court, in the role that.
But you have your own personal flavor and your own personal lean, I'm sure, right? I mean, that comes into play.
We
Like,
do, but let me give
What
you an
justice
example.
looks like to you might be different than what another judge would see a little, right? Some of that comes into play.
Sure, I mean, I think we're all a product of our life experiences and our work and everything else. And I think there's a lot of different approaches that you can take, but, you know, what I'd say, I guess, and I don't think you're asking me this, but like if there was a case that, for example, came up that I felt I couldn't be fair on, then I step aside. You know, so there's also cases that you might find this interesting. If I was the prosecutor on a case that is assigned to me as a judge, I can't hear that case,
Like
period.
years ago.
Right.
Has that
So-
ever happened?
Oh, yeah, it happens all the time.
Interesting, yeah.
Because I was a prosecutor that handled our special victims team in domestic violence. So there's a lot of cases that are still in the system that I was the prosecutor. So, you know, I get my calendar and, you know, staff is great about catching these. But sometimes, you know, if it's an older case, it might not be immediately apparent. But, you know, it makes me chuckle if I see that I'm still the attorney of record. If I was the attorney of record, I can't hear it because our courts made it clear that if you were the attorney on one side or the other and you were active on a case, then you can't sit as a judicial officer.
Yeah.
So, but of course, there's gonna be individual differences but that doesn't change the fact that all the judges follow the law and follow the rules. But you're right, I mean, we're all a product of our own life experiences, and that's gonna make us view certain things differently. I mean, I think that's just human nature. And you wouldn't want us all to be robots.
Yeah. AI, failed decision.
It's coming.
It could happen, right? Scary world. It could be that system where
Scary world.
everyone gets held or no one gets held, where you have these absolute sort of situations, which I don't think serve the community well. But, you know, these are tensions, and I appreciate you probably all get questions about all these things. And again, I just promise you that if you have questions, obviously I can't talk about individual cases, but I'm always happy to have this type of conversation because it's super important. And I want you all to feel that you have a good sense of what goes into these decisions. I don't want it to be a system that you feel that you don't understand why something's happening. I want you to understand. And of course, people can, and we get it. I mean, I was talking with a friend of mine that, you know, I make decisions all day, every day. You know, I'm on the bench pretty solid. And, you know, there are people that aren't going to be happy with any individual decision I make. And that comes with it. You know, people are going to second guess. And that kind of comes with the territory. But, you know, from my sense, it's like I try to do the best job I can on every case that comes before me, everything. And, you know, someone does grade my homework, it's the Court of Appeals, you know, and someone grades their homework, which is the state Supreme Court. And of course, you know, what I'm saying is I care, and I want you to feel well equipped when you get questions to understand, at least from my perspective, why the system works the way it does. And, you know, I had this conversation with the sheriff too, because he was, I think, curious about certain things. And I think he ended up talking to the prosecutor, and they went to the legislature on a couple of things. And, you know, that's the beauty of our system of government, which again, I think is the best system of government in the world, even with all its flaws. And of course,
All about balance.
it's all about balance and
Yeah,
finding that
it's-
sweet spot of everything. And it's tough because there are times where doesn't it feel like there are times we swing way too far one way, far too the other way.
Society does the same thing.
Yep.
It's worth keeping in what you said though about the vast majority. Like, for example, if in Alaska, we had something called third-party custodians.
Yeah.
And it was like really popular and the judges wouldn't let you out without a third-party custodian. That means somebody that's willing to basically sign a form that says they're on the hook criminally for
Oh.
keeping you within sight and
God.
sound
Yep.
24
Like
hours. A
co-signing your-
babysitter.
But that's the old idea of bail.
But just give me
I mean,
an
that's what it
example.
was.
So if 95% of people are compliant with, well, if 90% of people are compliant with bail if they don't have a third-party custodian, and 95 if they have one, you know, statistic can go, you know, to tell the judges, twice as likely to fail if they don't have a third-party custodian. Well, that sounds pretty significant, right? So then you start doing 30-part custodians on every, well, but that means that 90 people are getting a babysitter that don't need one. So you can try to get 5 more people compliant out of, so you can drop 10 non-compliant down to 5.
Sure.
But you've just
Well, what are those
ruined the
other
lives
five-
of 90
what are those other
people.
five doing? Did they murder
Well,
people?
that's a
Did
good,
they-
that's a
how many
question to
people
be
did they
asked.
rape? You know, like.
Well, I'm just saying, like in these were on domestic violence and DUIs, misdemeanors level.
I think the Alaska system, I mean, that was sort of the idea of, historically, the idea of bail was that someone in your family would vouch for you.
Yeah, it was
And,
crazy.
Yeah, it was very different. And then I think for a lot of reasons I've read a little bit about that, you know, the way America was and the way people explored and they went different places, they weren't necessarily, you know, they didn't have family that was there that was like, okay, you know, Joanna's in trouble. We're gonna rally around. We're gonna make sure Joanna does the right thing, and you know, we'll make sure she gets to court and do all these things. And you had a bail industry that got created that took the place of that, but took the place of it in a different, fundamentally different way. You know, we still have cases where we have family or friends that come to court and will vouch for someone, and those are things by the court rule we take into account. So, you know, what I'd say is each case presents complexities that might not be there at first blush. You know, and I mean, all the way around, like the more you dig in, which is why I encourage people, watch and listen to those prelims. Because I will tell you, to me, they're phenomenally interesting, but a lot of times, you know, when the court goes into one of those hearings, we have very limited information. We have a declaration from the prosecutor, which can be short or a little bit longer, but I mean, it's about this specific incident, that's it. You have the pretrial services report, which has the information that's been laid out in the APPR. It'll have other cases that are currently open that the person has or doesn't have. It'll have current warrants, if there are any of those that exist. It'll have their criminal history. You'll have that. You'll have a declaration from that person about their financial situation, which is very basic information. That's all you have when you go into the hearing. And then at the hearing, you hear from the deputy prosecutor, you'll hear from the defense attorney, you'll get a little bit more information. Maybe there's a representative there from the alleged victim. Maybe there's some support that's there for that suspect, that defendant. Maybe there's time to hear from those people. Maybe they choose to speak or not. And so you have like very limited information. And then that's at the beginning of the case, right? That first hearing. And so when you listen sometimes, there'll be things like, someone will say, well, I want a civil standby. Can I have a civil standby? Well, civil standby is an exception on if there's a protective order that gets issued. It allows one-time law enforcement to go with that defendant to the home of the protected party and for a brief duration for that person to be able to get items they need, like, you know, car keys or wallet or those types of things. But it can be, well, I missed.
Said their laptops so they can work or
Right,
clothes.
right. I mean, like the stuff that they need to live because they can't live where they were living. So it's like, and you think about that, but, and what'll come out though is, you know, maybe the allegations were super serious and you're going, well, has anyone talked, you know, has the state's representatives been able to talk to the alleged victim? Does it make sense to have that civil standby now? This person needs to work. You know, it's like you're trying to balance all these things. And that's the other point I'd say about research, that there are a lot of researches that's aimed at the importance of that pretrial decision, because it will say a lot about what ends up happening to that individual. You know, and you can imagine if someone, let's say, was working and someone was parenting and someone was doing all these things, but they made a bad decision. Let's presuppose that they are actually guilty of this crime. We're not to that point, but let's say that's the case. What impact does that immediate detention and have on everything else that's going on in their life, and what does it mean long term? And so, again, you're trying to look at, you know, from our standpoint, we're trying to follow the constitutional law and the court rule, but if you're looking at it as you all, as policymakers, you're also trying to say, okay, well, what is going to have the most positive effect for our community and what's going to be a negative effect for our community? And that's where, you know, looking at how many people do you house in the jail, what impact does it have on community members? And then I think sort of where you're naturally going to, which is, well, what about this small subset that there's a perception commit a large percentage of the crime? What do you do with those people? And, you know, there are no easy answers to all this, because what I would tell you is if there are easy answers, it would have been solved a long time ago. This is something that you have the historical perspective. Are these issues that have been discussed for decades?
Millennia.
Forever.
Forever.
All right, Judge, thank you so much.
Gosh, I feel like I took up a ton of your time. I hope I was able to answer the things.
Are your Zoom meetings available after hours on these hearings?
They're not. They're live.
So it has to be live.
They're live. Yeah, we don't record them, but they're live. So our prelims, except on after like a long weekend, which then they'd be 1:30 or 2. Otherwise, they start at 2:30 every day. So, yeah. Just like if someone, and the other option, of course, is, and I know this is harder for people, but they're always welcome to come to court. I love it when community members come to court, and I love to be able to talk with them about
Next year.
Yeah, there you go. But Zoom is an easy way for people, if they're available, that they can. So one last thing, and I'm leaving. April 3rd, drug court graduation. We talked about that. We've got 2 graduates. I think they both have really good stories, and you're welcome to come in person or on Zoom. So thanks for having us.
What time is that, Judge?
That would be at 2:30 on April 3rd.
All right, thank you.
All right, you got it. All right, I hope you all have a great rest of the day.
Thank you very much.
You're very welcome.
Very much. Good discussion.
Most definitely.
Thank you.
All right, you have a great rest of
Thank
the
you,
day.
Kristen.
See ya.
Thank you.
All right, so prosecuting attorney and sheriff, no dice.
Nope.
Sounds like we're
The
done then.
prosecutor apparently notified us that they were not available, and we had heard from the sheriff earlier today.
Funeral.
Yep, of he and undersheriff.
Okay, and we're adjourned. We'll be back for Board of Health, 3:45.
Great.